So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, you know, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights?
America's legal system is built on a critical principle. Judges must be impartial, applying the law without yielding to personal or political biases. But what happens when ideology finds its way into the courtroom? When decisions lean toward activism over the rule of law? Today, we examine the case of Judge Sarah Netburn, whose 2024 nomination to the U.S. District Court for the Southern District of New York has ignited heated debate. In 2022, Judge Netburn made a controversial recommendation to transfer a biologically male inmate convicted of serious sexual offenses against minors to a women's prison. This decision drew strong reactions from critics, sparking a wider discussion about judicial neutrality and the implications of such rulings for inmate safety and rights. During her Senate Judiciary Committee hearing, led by Senator Ted Cruz, Judge Netburn's record came under intense scrutiny. This was no ordinary review.
Well, Judge Netburn, I want to continue on this line of questioning. In your court, what matters more, the rights of individuals or your political ideology?
I apply the law to the facts.
I asked a question, which matters more?
Well, my political ideology doesn't matter at all.
Okay, so I don't believe you. And I think this case demonstrates that you are willing to subjugate the rights of individuals to satisfy your political ideology. This case involves a male defendant who raped a 9-year-old boy. Was he guilty of that?
Yes, the petitioner pled guilty to that.
Okay, so he raped a 9-year-old boy. He also raped a 17-year-old girl. Was he guilty of that?
He pled guilty, the petitioner pled guilty to that crime as well.
So was he guilty?
I hope so, because she pled guilty to it.
He was a he when he did this.
That's correct.
And also criminal deviant conduct, which the record doesn't disclose what that was exactly. Then, after serving in prison, Mr. McClain was released for parole, but then violated the terms of parole by having internet and was sent back to prison. 1 year after being released again, he was convicted of having child pornography. Is that correct?
I'm unclear on exactly the time frame that you're at, but the petitioner was convicted of distributing child pornography.
Child pornography that was images of adults violently raping children.
Abhorrent conduct.
Okay.
For which there are real victims.
And this individual, 6'2", biologically a man. A minute ago, you said that when this man decided that he was a she, you said this individual was, quote, I wrote it down, sober and entirely a female. That phrase struck me as remarkable. Did this individual have male genitalia?
I think what I said, or at least what
that is a verbatim quote, entirely a female.
Sorry, what I meant to say was hormonally a female.
Okay, but that's not entirely. Did this individual have male genitalia?
Yes.
So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, you know, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights?
Is that a question you're asking me?
Yes, the other women in that prison, do they have any rights?
Of course.
Do they have the right not to have a 6'2" man who is a repeat serial rapist put in as their cellmate?
Senator Cruz, I considered the facts presented to me, and I reached a decision based on what the law is.
I asked you a question. Do they have a right not to have a 6'2" man who is a serial rapist put in as their cellmate? Do those women have a right to that?
Every person who's incarcerated has the right to be safe in their space.
But you didn't think so. You didn't think so. And in fact, I'm going to give some quotes from your order because Senator Kennedy is right. This is not a judge's order. This is a political activist. By the way, the beginning of your order says, at birth, people are typically assigned a gender. I got to say that would astonish a lot of Americans. A lot of Americans think you go to the hospital, a baby is born, and congratulations, you have a little boy, a little girl. The assigned a gender, I know you went to Brown, but it sounds like it's in a college faculty lounge. with no bearing on reality. The Bureau of Prison argued what I'm saying right now, that if you put this person in a female prison, there will be a risk of sexual assault to the women. And you know what you did? You said you didn't care about the women. I'm going to quote what you wrote. You wrote, quote, "The Bureau of Prisons claim penological interest in protecting female prisoners from sexual violence and trauma. This interest is legitimate," that's kind of you to say, "but there are no signs that petitioner is at risk of reoffending. The record is devoid of evidence of incidents of violence or assault during petitioner's incarceration when she was the perpetrator, only the victim. A theoretical risk of sexual assault by the prisoner without more cannot support the BOP's position. No evidence, theoretical." Have you dealt, in what universe is someone who is a serial repeat child rapist not at a risk of reoffending?
Senator, as I do in every case.
Okay, I know you've been told to repeat the line, "I follow the law." I asked a question. In what universe is someone who is a serial repeat child rapist not at risk of reoffending?
Sir, I looked at the facts that were before me in this case. All of the evidence, including the statements of every warden who had supervised this petitioner.
You also wrote, "The BOP also posits that permitting petitioner to live among women will be traumatizing and possibly dangerous to them. This concern is overblown." I have to say, if I were the father of one of those women, and you decided that my daughter's cellmate was going to be a 6'2" man who over and over and over again committed violent sexual assault, I would say the entire justice system is absurd, and it is clear on your record your political ideology matters a heck of a lot more than the rights of those women that you endangered. I think you're a radical, and I think you have no business being a judge.
Netburn's responses reflect a disturbing tendency among some judges who may downplay the risk to justify decisions that align with certain ideological views. This response from Netburn raises concerns about a disconnect from common sense from a judge whose ruling can significantly impact many. The following push from Senator Kennedy reaffirms her position on this matter.
And you told the Board of Prisons, well, she'll be okay. The other women in the female prison will be okay because it's only hypothetical that Ms. Shelby, Mr. McClain would reoffend again after he's already raped a 9-year-old boy and a 17-year-old girl and has been sending child porn through the mail. You said there's no chance he'll reoffend again. Did you say that?
Senator Kennedy, I based my decision on the record.
But am I right? Did you conclude that?
I don't have a specific recollection of that. I did recommend that after finding a constitutional violation.
What were you thinking in saying it's only hypothetical that she would reoffend?
The facts of the case were that the petitioner had last engaged in a contact offense 30 years ago. The petitioner had not engaged in any contact offense. In addition, the medical evidence made clear that for the last 5 years, the petitioner was sober and hormonally entirely a female, and there was no evidence.
The Board of Prisons didn't agree with you. I'm not going to run out of time here. You're really a political activist, aren't you?
I am not, sir.
But your record demonstrates otherwise.
Senator Kennedy's words strike at the heart of the matter. When judges impose ideology over legal responsibility, they undermine public trust and safety. This hearing underscored how even well-meaning beliefs can lead to dangerous outcomes in the hands of judicial activists. In a written response to Senator Cruz, Netburn previously confirmed that she has no regrets about her transfer decision. Since then, Republicans on the committee have received over 100 letters from women, women's groups, and female inmates voicing concerns about the safety risks women face when housed with biological men. In Judge Netburn's hearing, she downplayed the risks posed by a repeat offender, specifically a convicted serial rapist. Senators Cruz and Kennedy pointed out how dangerous it is to assume there's no ongoing threat from someone with such a violent record. Ignoring this risk goes against a judge's duty to prioritize public safety. In July 2024, the Senate Judiciary Committee voted 10-11 against advancing Judge Netburn's nomination. This rare rejection sent a clear message that judicial impartiality must prevail over ideological influence, particularly when public safety is at stake. In his press release after the rejection vote, Senator Cruz welcomed the decision, saying, "This is a massive victory for women everywhere. Today, sanity prevailed." The case of Judge Sarah Netburn serves as a stark example of the risks associated with judicial activism. When a judge allows personal beliefs to cloud their legal judgment, they jeopardize not only public safety, but also the foundational principles of impartiality and justice. If you found this video informative, please like and subscribe for more content that challenges prevailing narratives.